My name is Sean Timmons. I'm the managing partner of Tully Rinckey PLLC's Houston, Texas office, and I litigate cases around the world with my colleague Allison Weber and many other attorneys with Tully Rinckey. We have a Rolodeck of sophisticated, credentialed, skilled attorneys that litigate court martials. We have Ernesto, we have Ira, we have Michelle, Eric, you name it. I'm leaving names off deliberately. I don't want to go through the whole Rolodeck of everyone, but we have a 20 plus veterans, many of them who are former JAGs, many of them with decades of court martial experience on the team. And we're going to talk this morning about why it makes sense to bring in a more experienced court martial attorney than to rely simply on the court appointed counsel or government issued counsel. Government issued counsel is your fundamental right under the Constitution, but again, when you're assigned someone who's doing it as a task that they're kind of compelled to do, you may not get the effort and energy required for diligent representation. And the importance here is your life is at stake. I would analogize it to a heart surgery, and we'll talk about that later. But as an introduction, I've done court martials for every branch of service. We've had a series of full acquittals. In fact, there's a prior webinar from a couple weeks ago discussing some war stories from full acquittals. I know Allison has done other webinars, and I'll pass it over to let her introduce herself.
Good morning. I'm Allison Weber. I am a partner out of the Buffalo, New York office. I'm appearing remotely though, so hopefully my internet connection maintains throughout this presentation. I, like Sean, have handled cases around the world in various branches, and I can't agree enough that you never know what you're going to get with the appointed counsel or the, assigned counsel. And at the end of the day, the most important thing is that you have a good relationship with your attorney and know that they're fighting for you.
And we're going to go ahead and walk through some more specifics about all that. So in today's webinar topics, we're going to discuss the weakness generally applicable across defense counsel provided. Now, I'm not disparaging any trial defense attorney. Many of my colleagues were trial defense attorneys. Joe Wilkinson, my colleague in Washington, D.C., was a very, very talented trial defense attorney with great accolades, and I think he's got citations in court cases. So there are, exceptions to the general rule that you get deficient counsel. There's many great trial defense attorneys, but again, kind of like roulette, are you going to draw 2 black, or are you going to get a number that's green or red when you put all your money out? I mean, rolling the dice is never really a smart decision when your life's on the line. So I personally would not put my house on 2 black on the roulette table, but some people do, and you got a 3% chance of it turning out as a great return on investment. Otherwise, 97% chance it's not going to work out for you. That's just one example of why government appointed counsel may be problematic. Principal reasons to retain civilian counsel we're going to talk about primarily today. Other reasons to retain civilian counsel beyond just the fact that trial defense may not give you 110% effort is trial defense will tell you, and they'll admit flat out, there's just certain things you're not allowed to do. There's rules governing attorney conduct in the Army, Air Force, maybe Marines, Coast Guard, and the restrictions limit the capacity for representation significantly, meaning their task is laser focused. They're only allowed to do X, Y, and Z. They can't deviate and do A, B, and C. We'll talk about some more specifics about that, but generally, a civilian attorney is only limited by generally applicable regulatory framework, meaning you can't hire an attorney to do anything illegal. We're not fixers who can stop an investigation. We're not people who can cover up crimes. That's not what we do as attorneys. We advocate within the law as your advocate to fight back on your behalf lawfully. And we can do everything lawful to the fullest extent. We're not restricted by any regulatory framework that says, oh, you can only do A, B, and C, and that's it. However, we are limited to what we can do because every attorney is limited. They have to follow the law and they have to conduct themselves accordingly. We're not TV lawyers that hide evidence for clients. That's not the kind of thing a civilian attorney can do. And I tell people that up front because you'd be surprised. Some people hire me thinking that we can do stuff like that, and we certainly can't. However, what we can do is give you 125% effort for the full duration of the representation and do outside the box stuff within the confines of the law. We also work as a team. Again, 20 plus veterans on the team. Me and Allison have worked court martials together before, and we work great together. But we have many other attorneys that are capable and skilled and available beyond the two of us. And we're going to go over some war stories, explaining how civilian counsel made a difference that was dispositive, I believe. And if you had simply relied on inexperienced counsel, the odds would have went down considerably regarding a favorable outcome. And I also want to talk about today some of the warnings about some civilian defense counsel. You shouldn't just hire any attorney in the phone book or on the internet or on a web page. You really need to do a deep dive into their credentials, into their experience, into their background, and make sure they've actually done court martials. Any attorney with a law license can hang a shingle and tell the world on the internet how great they are as an attorney. But if they're on Instagram all day, I guarantee they're not in the courtroom. And if they're not in the courtroom and they're only on Instagram or TikTok or Snapchat or you name it, they're not actually doing any legal work. So I would be very skeptical of attorneys who appear exclusively on social media but don't have any documented success behind their social media presentation. There's a lot of social media lawyers out there who only sign people up and then ship them off with bad outcomes. There's a lot of attorneys that are really good at self-promotion, but do they actually have a track record of success? That's a question mark. All right. Generally speaking, and I'm going to ask my colleague Allison to weigh in on this, but we do have a primary list of weakness in government provided defense counsel. Number one, inexperienced. Usually, they have 2 to 4 years of experience. I'm on year 17 as an attorney. I know Allison's been an attorney for over a decade, and I'll let her go into her background a little bit deeper in a moment. But I've been an attorney 17 years, and I can affirmatively vouch for the fact that when I started, I was not nearly as good as I am now. You learn things as you go, kind of like fixing a tire or riding a bike or swimming. You get better at it as you do it. And as an attorney, it's probably one of the few occupations where the older you get, the more you've done it, the easier it becomes. If you're a bricklayer, your body gives out. It's harder to do it. Older, your body aches. Laying bricks gets to be problematic when you're 50 or 60, potentially because your body's not as youthful as it was at 20. Well, as a lawyer, as long as your mind is sharp and you exercise it by reading and keeping it fluid by practicing, generally the job gets easier the older you get. And that's really a positive. So generally speaking, again, very generic speaking, but the more experienced attorney, it's just going to be better simply because they've been through more situations. Number two, trial defense attorneys are overworked. I know from my own experience working at Fort Hood, trial defense would show up at 6:30 in the morning for PT and not go home till 10 p.m. at night. I had a neighbor of mine in my neighborhood in Georgetown, Texas, who drove 35 minutes from Killeen back to home, and he would arrive home every night after working his trial defense services job by about 11 o'clock at night. And then he'd get up at 5 a.m. and go in for PT because the unit made him show up for PT, and he would work 5 a.m. to 11 p.m. 5 days a week and all weekend long doing motions and preparation for trial. That kind of work schedule is going to burn you out and exhaust you. Our attorneys work very, very aggressively, and we work long hours, but we don't work unreasonable hours under duress, 5 a.m. to 11 p.m. every day. Maybe in trial, that's the schedule I hold, but I don't go to trial every day, and that's a difference. We keep we have also a very good work-life balance at our firm, so we work really hard, but we also have 3 weeks of vacation a year that we pay for as a firm, which is very few law firms pay that kind of level of benefit. So we keep it a balance. Trial defense, they burn their attorneys out deliberately because they know it's a rough assignment. You work trial defense for 2 years, you work grueling hours, then you go work in ad law, and you get to work 8 to 5 for 2 years also. So the JAG Court balances it out, and the trial defense attorneys thinking their next job's coming up soon. So how much are they really going to care about their current role when they're daydreaming about their ad law role at a new posh location, maybe in Hawaii, and now they're in Fort Hood, Texas, doing TDS work that they hate, and they're only thinking about their new assignment coming up. That's something to keep in mind. The inability to challenge senior military leaders is a critical difference. I personally, and I believe Allison shares the same belief, I don't care who I piss off, and I'll be blunt about it. Why? Because by the time I go back to that installation, nobody's going to know who I am anymore. Generally, if I go to trial at Andrews, I won't go back for a couple of years. So by the time I go back, nobody who I angered previously is still going to be there, nor remember what we did previously. So we have no problem confronting senior military leaders, calling them out for corruption, challenging them on their conduct, and filing appropriate complaints and efforts. We also deal with in the military the constant PCS moves. Anybody who's been in the JAG Corps knows every 2-3 years, you're every summer you're moving somewhere else. Well, if you're always focused on household goods shipment, selling your house, renting your house, moving your family, changing your kids' schools, how much effort are you going to be putting into your day-to-day job? I work 6 minutes from my house. That meaning when I'm not in trial at Fort Carson or Los Angeles Air Force Base or Navy Base San Diego or flying to Germany or wherever, I'm 5 minutes away from my house. So that's a great work-life balance that our firm allows because we have so many offices and so many attorneys, and we're not dealing with the constant juggling of our life. My life is pretty stable. In fact, it's incredibly stable compared to where it was when I was serving in the military, having to deal with always moving around. That means your trial defense attorney, are they going to be worried about your case? Or are they going to be worried about selling their house? Are they going to be thinking about your particular trial strategy? Or are they going to be hoping to hand your file off to the next TDS attorney who's going to replace them and leave you with somebody who has no idea what's going on? Desire to seek pretrial disposition. This is the part I want to talk about that a lot of flat fee attorneys do. I would be very skeptical of a court-martial advocate who tells you, give me X amount of money, flat fee, I'll do everything. What that really means in English is they'll put your money in their wallet, spend it, and then sell you up the river. Meaning by the time it comes to do any work on your case, they're going to tell you, sorry, nothing I can do for you. You better plead guilty. And if you force a trial, they'll half-ass it deliberately because they haven't done any preparation because they already spent all your money. And it's flat fee, so their incentive is to do the least amount of work possible and keep the most amount of benefit. We don't charge flat fees precisely to avoid that ethical dilemma. You pay as you go with our firm and with any attorney who's, in my opinion, ethical, because you should only pay for the service you need as you go. If you do a flat fee and you give somebody $20,000 up front, are you going to get $20,000 worth of work, or are they going to keep it all and show up and do the bare minimum and then watch you get handcuffed and right off to prison? That other later scenario, I've seen it too many times. I've seen attorneys disciplined, ethical filings. I've watched careers and livelihoods be ruined and attorneys lose their practice because of that exact kind of behavior. It's all too common. All too common for JAGs to get out of the JAG Corps, try to start their own practice, take a bunch of flat fee money, spend it, and then when it comes time to advocate for their client, forget their client exists and do the bare minimum, if anything at all. Avoid that kind of individual at all costs. Another problem is many trial defense attorneys simply don't understand the long-term ramifications. So many times people have come to me later, oh, I didn't know I was going to be a sex offender. Well, your attorney was required to look into that. My attorney never told me I was going to be on this registry for the rest of my life. Or my attorney never told me I was going to get deported if I pled guilty. Or my attorney never told me X, Y, and Z. They often don't truly know the consequences of the collateral issues associated with your guilty plea disposition. So I would certainly have a civilian attorney who's more credentialed, who's more experienced, review any terms and conditions of any plea arrangement to look not just for the agreement's content, but what are the collateral consequences? Is this going to result in me losing access to firearms the rest of my life? Is this going to result in me having to register on a registration paperwork where I can't live within 5 miles of a school? Am I going to be stuck working McDonald's drive-thru the rest of my life if I take this plea deal? Am I going to lose my clearance? Am I going to lose my credential and my professional occupational license? All these collateral consequences can come from a, quote, deal that, quote unquote, makes it go away. It doesn't make anything go away other than your file that attorney who gets to move on to the next case. So I would be very skeptical of an attorney telling you, yeah, just take this, it'll all go away. That is a load of horse manure. And again, I apologize for being crude, but you're talking about your livelihood here. And I'll invite Allison now to fill in any gaps I may have created here with my diatribe and add in any content and her perspective, please.
Absolutely. So I wholeheartedly agree about the inexperience. So while I was in the JAG Corps, I thought I was a great prosecutor until I became a defense counsel and realized how bad I was as a prosecutor. Once I got done being a defense counsel, I realized a much bigger scope. And that's how it works in the JAG Corps. You just keep jumping from job to job to job and never get to fully develop your experience. Whereas like Sean, I'm in my 15th year, I believe, of practice, all of which has been military law pretty much. And it's amazing how far I've come from where I started. And my was at year 2. I finished 2 years as a prosecutor and immediately became a defense counsel at Fort Bragg, which another very, very busy base. And going to the overworked, I cannot agree enough. Even if you have the most committed, best defense counsel in one of those offices, they're still working 15 to 17 court martials probably. And that doesn't sound like a lot, but if you think of how much effort goes in every day to those cases, and those are just the court martials, that's not the walk-in appointments, that's not the Article 15s, the chapters, the boards, I know there was a day I had to report to a board at 5 o'clock in the morning because I had to go to court that day. So they insisted upon having a separation board at 05 in the morning. And I had to leave with the client's permission, obviously, but I had to leave before they even announced the outcome because I was in trial at 09. That happens as a military attorney. You can't do anything about it. You're ordered to be one place to the next place. You have to do what you have to do. Whereas as a civilian, they would never get away with that. It's not the same. So, the TDS attorneys, like I said, even if you get the most committed ones, they're overworked. They're struggling. And certainly by the end of the time there, they are about it. The ability to challenge military leaders it does make me chuckle because like Sean, I have absolutely no qualms about challenging anybody. Certainly not military leaders. And for me, it doesn't even matter if I would appear in front of them again, the next week. At the end of the day, they can't do anything to me. I need to hold them accountable. That's my job to hold them accountable. As a military attorney in the military, you are, kind of bootstrapped into what you can and can't do. I know you cannot use the word unethical without running it up at least 3 levels of your command before you say it. And if anybody thinks you're going to say it out loud, they immediately halt the trial, right? Like it's an amazingly chaotic thing when an actual military defense attorney goes to make such an accusation because they have to have all these levels of approval before they can open their mouth. We have no such issues. We can call out the attorneys, we can call out the command, and we do so. I mean, obviously, again, as appropriate, but we have no problem doing that because they can't do anything to us. In fact, I I believe that I made a good deal of my reputation by doing such things, by upsetting people. I mean, if your name's floating around as, oh, that person's, she's going to hold your feet to the fire, she's going to, make you work for everything, then they know that going into the next case. Um, The desire to seek a pretrial disposition is not just with civilian attorneys that do flat fees either. The military attorneys, again, they have too many cases. They're triaging. They're trying to decide, okay, hey, this one is a really hard one to win in our opinion, so you might as well just plead guilty so I don't have to spend all the extra time into this case, whereas I can put it into the other cases that are more, easily winnable. I can't tell you the number of times that I get a client in the civilian side who came to us because they were told to plead guilty. And then we either get a full acquittal, which is obviously the goal in most cases, but in some cases that isn't the goal because they know they're stuck, right? But we get them to a much more reasonable deal. I remember a case just a couple of years ago where the deal on the table for the military council was a year of confinement. We got that deal reduced all the way to a few months. So it's a massive difference when you're looking at, why are you pleading? Are you pleading just because the attorney doesn't have enough time or energy to work your case? or are you pleading because it's actually in your best interest? So it definitely happens on the military side as well. And you also, I know I experienced this while I was there. You have two types of attorneys. You have the people who want to go to TDS because they really do believe in the justice system and believe in defending people guilty or innocent. You also have the people who absolutely are government hacks who never should be assigned to TDS but get assigned there anyway. And those people often, like, they brag about how many guilty pleas they have as opposed to contested trials when it should be the other way around. So they're not doing it for the client's benefit. They're doing it to make their lives easier and because they would rather check the block and move on. So and that goes right into the last one, the poor understanding. If you don't, you have to have a full understanding of what you're committing to when you're doing it. If you don't, especially if you plead guilty, right? You go to the appellate court and you tell them, well, they made me do it, or they coerced me into doing it, or I didn't know any of this. But they're going to say the exact opposite. And you in the trial said the opposite. You had to tell the judge you knew everything and understood everything. So you really put yourself in that position where you've ended it before you ever started if you don't actually find out the real understanding of your case and whether you should be pleading, whether you shouldn't. And the other thing, I believe Sean will tell you this too, is we're realistic. I mean, I will tell a client, like, hey, you have a hard case. Like, it may not be a full acquittal type of case. We will certainly try everything under the sun, but sometimes you need to be blunt, and not every military attorney is able to do that. They want to sugarcoat things. They want to make you feel confident in them as opposed to just getting the straight facts of what they're facing. You need to know the facts in order to make your decisions. So those are all reasons that I think it's easier to work with a civilian attorney, and especially one that's doing an hourly rate who objectively wants to be involved in the case and just across the board cares about what happens. I think that's most of the ones for this one.
Thank you, Allison. That's all a great overview. And I wholeheartedly agree with everything Allison said. And again, another reason why we're such a team is there's some stuff I left out. She filled in the gaps, and vice versa. We do that for each other. We have a quality review of everything we file. So we have a practice chair who looks over every pleading we submit to the court prior to it being finalized. So if an attorney submits something that's about 90%, that other 10% is filled in by other attorneys within our practice. And that difference could be dispositive. And that's critical to having a team. If you hire, Bob DeSolo outside the gate, is Bob DeSolo going to have somebody checking his work other than you, the client, who doesn't really know anything about the law? Or are they going to have somebody, that you work with as a team who's also equally credentialed and experienced? And it's always better to have a surgical team than it is to have somebody flying solo. And nobody flies solo at Tully Rinckey. We work together as a large group. Now, admittedly, sometimes people get frustrated by interacting with more than one person. We generally assign one case, one attorney, but each attorney has the entire practice to go to seek additional information to fill in any missing gaps that might be necessary. And if your life is on the line, you're going to want that additional firepower to fight back against the government, because the government's going to have a whole team. They're going to have the agents. They're going to have their own private investigators. They're going to have a litany of experts. They're going to have senior trial defense counsel. They're going to have senior mentors from the Trial Counsel Assistance Program, TCAP, and TCAP's going to send in a major, two captains, people who are very knowledgeable to go up against a trial defense attorney who just graduated law school. That's how they stack the deck. They deliberately put a major and two captains against one captain who just graduated law school. I saw it a couple months ago at Fort Bragg. It happens day in and day out. And that to me is
Or even a
totally
lieutenant.
unfair. Or yeah, even a lieutenant. So they'll put in a lieutenant against a major. So the major is the government attorney with 15 years of prosecution experience, and the lieutenant just finished law school and trying their first case. That could be you in court, and those odds look pretty grim just from that setup alone before you know any facts of any case. Principal reasons to hire private counsel. Again, I think we talked about some of this already, but experience, decades of it, all of us here at Tully Rinckey, most of it in uniform, much of it in uniform. Personal attention. We have a practice chair that controls our caseload. No attorney. We also have a level system. So if an attorney is low on work, they get assigned more cases. If an attorney is tied up in trial, they're assigned less cases. And that balance process is something that we manage pretty clearly. There's Fort Bragg or Fort Hood or Fort Bliss or other installations around the military really manage the caseload of their trial defense attorneys. Not really. It's on the attorney to get rid of their cases as fast as possible and focus on moving on to the next job, which means their personal attention to your case is going to be minimal, if any at all. Again, additionally, meticulous preparation. We prepare for multiple eventualities and outcomes, and that gets expensive. Fully admit it's expensive to hire a civilian attorney, but would you rather pay for preparation or winging it? Winging it when your life is on the line is not a strategy I think that is prudent. Fearlessness. Again, Allison explained it. She's not afraid to go up against anyone, anywhere, anytime, even if it's 3 days in a row. That's why I love having her on the team. I'm a little more diplomatic than that, but I'm still going to go up against anyone, anytime, and not have any concern about the blowback from it. Focus. We are laser focused on every client at all times, and results oriented. We don't get business unless we produce good outcomes, and we have to strive for the best possible outcome day in and day out. We can't win every case. There's nobody can, and we'll never say that to anyone that we have a formula where there's a particular outcome that's guaranteed. That's totally not possible, and we make no claims of such. But we can tell you, by putting in the extra effort, energy, and diligence, and focus, and awareness, we can increase your odds. And we can increase the odds substantially by putting in that extra effort. Awareness, as Allison explained, we're fully aware of the consequences of any outcome that results in any disposition. The goal is always to get that grand slam full acquittal, but sometimes it's not possible. For example, I've had cases where my client was accused of sexual assault, and the fact pattern was he was a senior officer, and the quote victim was a private in the Army or senior subordinate rank. Well, just hypothetically, if you're a captain and you're sleeping with a private, that's automatically illegal. Doesn't matter if she threw herself at you totally, and if you knew she was a private in the Army and you're a captain, you've committed fraternization. You've committed misuse of authority, possible maltreatment, possible conduct unbecoming. There's a whole litany of crimes inherent in just the existence of the relationship. But are you a sex offender? No, of course not. If it's voluntary consensual sexual activity and you're charged with sexual assault, we can defeat that and protect your long-term livelihood and ability to have a life after the military. Is your military career over? Probably. But is your livelihood over? No. Are you going to be able to have a life where you can live where you want to live in the future? Most likely, yes. Are you going to be completely exonerated? Probably not. But are you a sex offender? Absolutely not. If it's consensual sexual activity and you're falsely accused, we can defeat that. But if it is independently corroborated that the activity did occur, you're probably going to be found guilty of something, which is why we're fully aware of how to game out any particular outcome and get you in the best possible situation for the best possible resolution, even if the evidence looks pretty grim. I've had confessions suppressed. I've had admissions against interest erased. We've kept evidence out of being presented. So even if you think it looks pretty grim, fighting can do wonders. It really can. I know Allison's kept out stuff that I was surprised the judge ruled in our favor, to be fully blunt. So the more effort you put into it, more outcomes, even if they're against the odds, that can happen. I wanted to add additional reasons to hire civilian counsel. What we know to do versus say a less forceful attorney. We know which motions to file. We know which experts to demand. We know that you have to request experts and then file motions to compel production of the experts. A trial defense really going to focus on filing motions to compel production of experts and demand the government spend money on those experts, or are they just going to roll over and say, okay, we didn't get the expert we wanted, let's move on? We know which appellate cases to cite. We track appellate decisions daily, and we monitor that activity on day in, day out. We know how to select the jury, the panel. We know how to ask questions of voir dire and how to. And I've won cases on the techniques for voir dire. Don't want to give away a secret sauce here, but the more you do voir dire, the more you learn about interpersonal actions and who's good for your jury for which facts, the better your odds become. We know how to apply the pressure to the government to try to, force their hand to drop charges or negotiate a better deal. We also know how to use the media when it's appropriate. And we also know how to use the congressional inquiry process and the IG process. And I can tell you, trial defense services, area defense counsel, they're not allowed to use the media at all, if ever. And they're certainly not allowed to help you write a complaint to Congress or an IG complaint. They're just prohibited by regulatory framework that says they can't do that. We could certainly use that mechanism if we determine it's necessary. We can also handle ancillary issues such as security clearance rebuttals, flippals, private issues associated with collateral consequences from whatever situation you happen to be in. And with that, I want to turn it back over to Allison.
Absolutely. I really can't tell you the number of cases where when the civilian counsel, in this case me, joined the case, it was like, oh, we need to do XYZ. Why wasn't this done already? The number of times a TDS attorney said, well, we didn't request experts because they just routinely deny them. That's nice. I don't care. We're going to request them. We need to request them. And you don't roll over before you've even asked the question. It doesn't matter that you know the answer. Again, at the end of the day, these issues are often dealt with in the motions to compel, and that's precisely why you have to do it. You have to put the pressure on and request everyone and make the government do their job. At the end of the day, that is a huge part. The government it's their job to prove the case. We're not supposed to help them. And sometimes TDS forgets how much pressure they do have, ability to pressure, areas where they can influence things. And then which experts? I mean, obviously we have a large pool of experts that we use routinely based upon the recommendation of one or the other of us. As Sean said, there's a large group of us. We've all had experience. We've all used experts, and we know, whether to recommend them to the group or not based upon those experiences. And having an expert get on the stand and all of a sudden just go off the rails is the last thing you want in a case, because now what should have been your most useful tool just became the weapon that, hurt you. I have seen that in military cases where, especially when we get retained for an appeal, for instance, where you're like, why would they put this person on the stand if they said this? And that's because you have to know your experts when you're hiring them. You have to know who to get and why, and then when to use them. Sometimes you get them to help you, but you don't end up using them to testify for one reason or another. A lot of times the TDS is just not experienced enough to know the ins and outs of those decisions. And so these are all areas where civilian counsel's experience comes in extremely, extremely importantly. And I mean, whether it's completely true or not, I will say the number of military attorneys who say, well, if you file it, they're going to grant it because you're a civilian attorney and they don't want to deal with you. So sometimes there's also a level where potentially simply because of being a civilian, they give us more leeway, which, okay, we'll take it, right? It helps the client. At the end of the day, it helps the client. And so however that comes to be, the point is that we are able to get those resources for the defense team that they don't have. And especially in cases where the defense is assigned, for instance, like lieutenant or a very junior captain, they just don't know. And it's not their fault. Again, I've been there. I was that person. So it takes time to develop these areas. And that's where getting a law firm that has military experience is crucial. I did want to touch back on one other thing Sean said, and the overworked nature of TDS. As Sean was saying, like our firm triages and rotates cases to both the right attorney for the case, as well as the attorneys who are available to handle the case. We don't want to overwork and burn out any particular attorney. We want to balance it across the board so that the clients are getting the best advocacy possible. I know that there have been times in the military where the senior defense counsel is assigning cases based upon their belief that someone's going to crack and self-refer for mental health. like go inpatient. They're pushing their attorneys to the point that they think they're going to break and refer themselves. That's their line, that they're deciding, oh, should I give this person another case? That's not healthy for anyone. It's not good for the clients. It's not good for the attorneys. It's not good for the system. And we know it happens. Again, they are overworked. There's just too many cases. So those are some things they're important to keep in mind when you're assessing whether or not to hire a civilian. The other thing is you get both the military and the civilian attorney. So they can balance each other in the process as well. It's not a either or unless you want it to be. So by getting the civilian, you're really only adding to your cause.
Thank you, Allison. That was great information, because it goes to one key point. We often use the local attorney for logistical support. So if you have an appointed attorney at Fort Carson, they might know where the building is for your separation board. They might know where this recent judge just ruled last week on a case in that particular courtroom. As civilians, we're going from jurisdiction to jurisdiction. So having a local trial defense attorney can be helpful for information gathering and just logistics. They know what hotel is the best one to stay at in the community. They know where to order pizza from. They know where to get, how to work the copier at the office. Those kinds of things are very, very helpful. So I would never advise dropping your trial defense attorney. Some people get worried that, oh, my trial defense attorney is corrupt, or they're working with the government. That's not happening. At least I've never seen it. It's possible, can't rule anything out, but that's generally not happening. But what is happening is when you hire a civilian, you're getting an attorney with much more experience who can help add value to representation and get you a much better outcome. But keeping your trial defense attorney on the payroll and working on your behalf certainly adds some value, because, again, at a minimum, logistical support is helpful. For nothing else than to help us get to the PX during lunch breaks at trial. So again, those types of things are all adding value to your case, and you want the trial defense attorney with you on your team. And having a uniform at the desk is helpful too. Even though we always explain our prior military experience, sitting next to a uniformed attorney does add value to a jury, to a panel that's looking over at you, and help you also make sure your uniform is all decorated out correctly and other basic stuff for military decorum purposes. But want to go on to the next slide about teamwork. We work together as a team at Tully Rinckey. I can't be more proud of the team we have. We have the best team in our military practice that I've ever seen, and I've been here for 9+ years now. I know Allison's been with us for at least 7, maybe longer. We've worked together for a very long period of time and gotten to know each other quite well. And you have to ask yourself, 1 + 1 can equal 3, the synergy, because having a civilian come in and having your assigned attorney works together kind of like a volcano. It maximizes the pressure and then it explodes. You want that massive amount of force to push back against the government, because, again, the government, their resources are unlimited. And I think one thing that can't be stressed enough is when you're offered an Article 15 and you're told, oh, it'll just go away. That is the most dishonest statement imaginable. It doesn't go away. When you become a civilian and you apply for a job, it's going to show up that you're titled for an offense and you committed the crime. I've had it in my office far too many times. People tell me, oh, I was told if I just took this 15 and didn't demand my right to a trial and didn't fight back, that everything would just go away and everything would be fine. And now I'm applying to work for the NYPD and they're telling me I'm a burglar, or I committed arson, or I committed all these offenses and I didn't do anything. All I did was X, and they're saying I committed a sex crime, and I can't get a job now because I took this Article 15 where the commander just told me it would go away if I just took this extra duty for 2 weeks. It doesn't go away. It looks like a conviction to the civilian world, and it has permanent consequences. And sometimes taking it is your best decision, but turning it down and forcing the government's hand might be a better outcome. You want an attorney with experience and knowledge to know the difference, not just push you to take what's convenient for them, which is the fastest way to get rid of the case. That's never the best solution. You always want a thorough examination on what's the best possible outcome. Think of your body aching. Do you want to just take Advil and hope it goes away, or would you rather have a full CAT scan to fully examine what may be causing the issue and a full resolution through all equipment available? It's more prudent to have an invasive examination of what your outcome is than to just, take 2 Advil and hope it goes away. Because for the military, it's not going to go away. We talked about a lot of different reasons why hiring a civilian attorney makes sense. Is there anything we've left out that you want to reiterate?
Actually, yes. So I was looking at my own war stories. One of the things that jumped out to me was a case I had just, I don't know, about a year ago up in Alaska, where we got brought into the case in large part because by the time the client went to trial, he was on his 3rd TDS attorney. The first one had ETS'd, the second one was PCSing, and because they knew they were PCSing, they gave up on the case long before ever really getting into it. But there was this overwhelming lack of continuity, not just because of losing the attorneys, but even in the logistical aspect, like the first attorney saving them to a drive that then a later attorney couldn't get into. I mean, the amount of issues that arose simply because of ETS and PCS is like just, it's enormous, and it happens all the time. I mean, sometimes you are able to keep your attorney when they PCS, but sometimes you're not. I mean, I know I flew back from Germany to Fort Bragg to handle a couple cases, but they intentionally try to set it up so that doesn't happen, and it happens all the time anyway. So that's a huge issue, especially when you run into those, because the logistical issues, because again, you end up like the last attorney that ended up working the case wasn't even local. I mean, semi-local. He was from the other office in Alaska. So when they're saying, hey, defense, why didn't you walk over to the TDS office? We're not there, right? Like the original people did, the original people stationed there did, but again, that was 3 people ago. So that was one of the ones that stood out to me. The others are having the I don't know, I guess personal courage to go up there and file motions to dismiss with prejudice when you believe that the prosecution is not upholding their responsibilities. For instance, with discovery, at least 2 of my cases were dismissed, one with prejudice based upon the government's reckless disregard for discovery. So that's something I think defense TDS is getting better at, but it's still a huge thing for them to jump in and basically call their counterparts, failures at their job who don't care. Again, we don't have issues saying these things. We don't have issues raising these issues. I mean, discovery is one of the most important parts of a case, and you can't just assume that the government is telling you the truth. And that's the other thing. A lot of times defense just trusts the government is telling the truth. You can't do that. You have to have the evidence. You have to have them provide it. So when they say, oh, I looked into it, there isn't anything, like you really need to hold their feet to the fire. And that's how we did. We got cases dismissed. So those are some things that just out of my own war stories, like kind of stood out to me. Also, obviously, like I said, negotiating better deals. I mean, just better results due to experience and experts. But specifically, I wanted to come back to that because it made a huge impact in the cases. Having someone who was willing to get into those issues and someone who was there throughout the entire process, not, attorney 3 who's trying to pick up at, step 52.
Well, thank you, Allison. That's all great, insightful information. At this time, I want to thank everyone for tuning in, and we do have some pre-submitted questions that were provided to us that I want to respond to. The first question deals with a question about defamation of character. The military is probably immune under government immunity from any kind of claims for defamation. Now, under the Federal Tort Claims Act, you can't recover anything from defamation. There are state law remedies in private capacity for defamation, so I would recommend anyone who's a victim of defamation to consult with the jurisdiction from where you live regarding any potential remedies against defamation or slander. I know in Texas we have what's called the anti-SLAPP statute, which makes recovery for defamation almost impossible. In Virginia, the Johnny Depp trial showed you the reason why it was in Virginia is the law there is very, very protective of libel and slander, and you can sue for it and get a trial and get a recovery. In California, it's like Texas, you really can't. That's why the Amber Heard Johnny Depp case was litigated in Virginia. But that's not really the scope of our webinar. And if you are a victim of defamation, you might be able to file an IG complaint. You might be able to ask for a congressional inquiry into the merits of what happened. You might be able to file an Article 138 complaint. You might be able to seek redress. Absent that, though, the remedies that are available to you are quite limited. Next question asks, what about a wrongful investigation into clinical competency? Well, there's a whole thing called peer review panels and medical suitability credentialing. My colleague Eric Duncan has done a webinar regarding credentialing and rebuttals and boards concerning medical licensing. I would invite everyone to watch Eric Duncan's previously presented presentation. If you're a medical provider and you're facing credentialing review, I've represented many doctors. I know Allison has also physicians who are facing scrutiny for their medical practice. That's outside the scope of why you should hire a civilian attorney for a military prosecution. But if you are a physician facing scrutiny in the military, you certainly want to protect your license and fight back against any national practitioner data bank report that might be forthcoming from military trying to ruin your credentials. And I see it all too often. The military has a systemic problem and they want to point fingers at one doctor and say it's all the doctor's fault, not the fact that the commander didn't, buy proper equipment, or the commander, forced everybody out in the mud when the procedure should have been inside a building, or whatever the issue might happen to be. Often they try to point fingers and point the blame at one unliked physician and just dump every problem at the whole hospital on one doctor. And that way everybody else gets absolved. That's totally unfair, but it happens day in, day out. I see it in my office every single day. It's quite exhausting. Does the attorney need to have military background or experience dealing with the military? No, technically, no. They don't need to have it. Should they have it? Absolutely. You really would want to have a heart surgeon who's operated on hearts previously. But if they have a license, and they can certainly do it, but I would be careful about trusting someone who hasn't done it before. To determine whether a commander has crossed the line, how do you determine next question, if a commander has crossed the line into harassment? Well, that's a tricky question because commanders are entrusted with the responsibility of enforcing good order and discipline. And what's harassment versus what's legitimate discipline is often a spectrum and gray. There's not a clear black and white answer on that, because commanders are, generally, as long as they're applying the standards equally across the board, if everybody's supposed to show up at work at 6:30 in the morning and you want to show up at 7, it's not harassment to tell you to be there at 6:30. That's ensuring good order or discipline. Now, if you're told to be there at 6 and everybody else told to be at 6:30, that could be considered harassment because you're getting treated differently. That's case by case specific, and it's really hard you really need to consult with the counsel to determine is it harassment or is it legitimate conduct. There's a spectrum there, and it's really facts. It's very, very fact dependent. And generally harassment requires repeated and ongoing maltreatment. One loan off, flying off the handle by court definition is generally not considered harassment. Even if it's vile, if it's isolated, that's not harassment. It has to be, harassment requires repetition, it has to be repeated. And if it's repeated, then it could be problematic. Next question, is it a violation of a veteran's civil rights for CID to investigate the individual's character after they separate or retire? No, it's not. Unfortunately, if you were a military retiree and you're getting military retirement pay, CID retains jurisdiction to investigate you for anything that may have happened while you were in the military. I often get people called in for accusations of war crimes from 20 or 30 years ago, and CID will investigate that. Whether they prosecute it, probably not, but it's still a possibility. And sometimes there's prosecutions that are 30, 40 years after the fact, and they have jurisdiction after the fact. You can't really do anything to stop an investigation. You can certainly seek relief in court if you're trying to stop a subpoena or file a motion to quash, records production. Or there's things you can do in courts to try to limit what the government's trying to do, but most of it won't be successful because, generally speaking, the government's allowed to investigate. People are often have a lot of anxiety behind that, but if you there's not really any limitation. If the government decides they want to focus resources on investigating you for whatever, they're allowed to do that. Your responsibility then is to have an attorney push back on your behalf to try to prevent them from, causing you harm. And the more you push back, maybe they'll decide, you know what, it's not worth the effort. Let's move on to something else, easier, low-hanging fruit. Next question, medical board versus chapter 14. That's really the subject of a whole different webinar. I invite you to YouTube to look at our separation board representation decisions and webinar presentations on that, but I will briefly answer it since it was asked in this seminar. A medical evaluation board determines whether you meet medical retention standards and whether you meet the criteria to continue to serve, or if you should be medically separated, either with disability compensation, severance, or retirement, or if existed prior to service and you get no benefits but you're medically released from continued obligation. A chapter is a punitive discharge generally that results in, a stigma associated with your separation. Generally, the general for enlisted has to make a decision, and for officers, it has to go up to the secretary level to decide which one is applicable. You really want to have a strong civilian advocate fighting for a medical disposition versus a punitive disposition. And all that is very, very fact dependent, very fact specific. So please be mindful of that. And that's all the questions we have. Allison, is there anything you wanted to touch on before we close on the webinar?
I believe one other one popped up in terms of identifying a civilian attorney that may not be right for your case when they don't throw up some of the red flags that we previously discussed. That's a difficult question in general to answer, but the one thing I will say is it's important to have rapport with the attorney that you retain, regardless of who it is. So if you are just the fact that somebody has military experience doesn't mean that you're going to get a good vibe from them. And I hate to say it that way, but that's true. If you don't get a good vibe from an attorney, that's something that you should be questioning whether you want to retain them to do such a significant, action for you. There's a lot of check their experience, check the way that they're setting up their contracts. A lot of those also, there was a question in there about limiting the scope of the contract. I mean, that's something that you would want to engage in a back and forth and see if they're willing to do it, trying to get those. If an attorney won't limit the contract the way you want to, then you probably don't want to go with that attorney. So there's some different ways that you can look at the attorney-client relationship, but at the end of the day, probably the most candid advice I can give you is warm and fuzzy, then that's a red flag in and of itself. If they are ghosting you or I think you need to establish the expectations up front equally. Like both sides need to say, here are the expectations for this representation, and then whether you're comfortable with that. That's a key part of it. So at the end of the day, like I said, you have to be comfortable with your attorney. I said that when I was TDS too. It's the one time a private can fire a captain. So if you're not comfortable with me, then I shouldn't be your attorney, right? If you're not comfortable with the situation, you need to step in and assert yourself on it. The rest is going to be very fact specific, so I can't really answer much beyond that, but I did see that question pop up.
Well, thank you, Allison, and thank you everyone for attending our webinar this morning. We hope that you don't ever need to actually hire an attorney, because hiring an attorney is never a pleasant experience. Kind of like dental work. You don't want to have to go to the dentist to get a root canal. But if you need it, you want to have someone who knows what they're doing. That's critical. Just like working on your teeth or working on your heart, you want to have someone with experience, knowledge, that's been vetted, and that can fight on your behalf. And again, I agree everything with Allison said, 110%. You want to have I invite everyone I talk to, I always invite them, look, go get another opinion before you hire me. Why? I want to make sure when we enter into this attorney-client relationship, we're doing it with both feet forward. We're holding hands as we jump into the pool. We're not doing it, without full awareness and full knowledge of the plan, the strategy, the goal, and the effort required on both of us to work together to get you the best potential outcome. And that's the necessity of an attorney-client relationship. It's a very personal relationship because your life depends on working together with your attorney to make sure you put the best foot forward to fight back against the situation you're facing. And everybody's situation is different, but we are familiar with the stressors associated with the advocacy required to put you in a good position. And I've given many hugs at the end of a trial after great outcomes. And generally, we don't give people hugs, but if the client wants a hug after a full acquittal, I'm not going to turn it away because I know what they've been through. And I had to deal with crying parents too many times. And we understand. And I fully understand the emotional stakes of it. But if you're faced with that break glass in case of emergency situation, when you break that glass and you have that emergency, you want to make sure you're calling in the A team, the team that's going to give you 110%. And that's, if you take nothing else away from this, take away from the fact that whoever you end up going with, make sure that they're fully invested in you and you're fully invested in them. And hopefully that'll help you get the best possible outcome, whatever you're facing. Thank you.